Hello, everyone. We're going to continue with Buckley v. Valeo. Two, blanket exemption. Appellants agree that the record here does not reflect the kind of focused and insistent harassment of contributors and members that existed in the NAACP cases. They argue, however, that a blanket exemption for minor parties is necessary lest irreparable injury be done is necessary lest irreparable injury be done before the required evidence can be gathered. Those parties that would be sufficiently minor to be exempted from the requirements of subsection 434 could be defined, appellants suggest, along the lines used for public financing purposes, as those who receive less than 25% of the vote in past elections. Appellants do not argue that this line is constitutionally required. They suggest, as an alternative, defining minor parties as those that do not qualify for automatic ballot access under state law. Presumably, other criteria, such as current political strength, measured by polls or petition, age, or degree of organization, could also be used. The difficulty with these suggestions is that they reflect only a party's past or present political strength, and that is only one of the factors that must be considered. Some of the criteria are not precisely indicative of even that factor. Age or past political success, for instance, may typically be associated with parties that have a high probability of success. But not all long established parties are winners. Some are consistent losers, and a new party may garner a great deal of support if it can associate itself with an issue that has captured the public's imagination. None of the criteria suggested is precisely related to the other critical factor that must be considered: the possibility that disclosure will impinge upon protected associational activity. An opinion dissenting in part from the Court of Appeals decision concedes that no one line is constitutionally required. It argues, however, that a flat exemption for minor parties must be carved out, even along arbitrary lines, if groups that would suffer impermissibly from disclosure are to be given any real protection. An approach that requires minor parties to submit evidence that the disclosure requirements cannot constitutionally be applied to them offers only an illusory safeguard. The argument goes because the evils of chill and harassment are largely incapable of formal proof. The dissent expressed its concern that a minor party, particularly a new party, may never be able to prove a substantial threat of harassment, however real that threat may be, because it would be required to come forward with witnesses who are too fearful to contribute but not too fearful to testify about their fear. A strict requirement that chill and harassment be directly attributable to the specific disclosure from which the exemption is sought would make the task even more difficult. We recognize that unduly strict requirements of proof could impose a heavy burden, but it does not follow that a blanket exemption for minor parties is necessary. Minor parties must be allowed sufficient flexibility in the proof of injury to assure a fair consideration of their claim. The evidence offered need show only a reasonable probability that the compelled disclosure of a party's contributors' names will subject them to threats, harassment, or reprisals from either government officials or private parties. The proof may include, for example, specific evidence of past or present harassment of members due to their associational ties, or of harassment directed against the organization itself. A pattern of threats or specific manifestations of public hostility may be sufficient. New parties that have no history upon which to draw may be able to offer evidence of reprisals and threats directed against individuals or organizations holding similar views. Where it exists, the type of chill and harassment identified in NAACP v. Alabama can be shown. We cannot assume that courts will be insensitive to similar showings when made in future cases. We therefore conclude that a blanket exemption is not required. Section 434E. Section 434E requires every person other than a political committee or candidate who makes contributions or expenditures aggregating over $100 in a calendar year, other than by contribution to a political committee or candidate, to file a statement with the Commission. Unlike the other disclosure provisions, this section does not seek the contribution list of any association. Instead, it requires direct disclosure of what an individual or a group contributes or spends. In considering this provision, we must apply the same strict standard of scrutiny, for the right of associational privacy developed in NAACP v. Alabama derives from the rights of the organization's members to advocate their personal points of view in the most effective way. Appellants attack subsection 434E as a direct intrusion on privacy of belief in violation of Talley v. California, and as imposing very real practical burdens certain to deter individuals from making expenditures for their independent political speech analogous to those held to be impermissible in Thomas v. Collins. 1. The role of subsection 434E. The Court of Appeals upheld subsection 434E as necessary to enforce the independent expenditure ceiling imposed by 18 U.S.C. subsection 608E1. It said, if Congress has both the authority and a compelling interest to regulate independent expenditures under Section 608E, surely it can require that there be disclosure to prevent misuse of the spending channel. We have found that subsection 608E1 unconstitutionally infringes upon First Amendment rights. If the sole function of subsection 434E were to aid in the enforcement of that provision, it would no longer serve any governmental purpose. But the two provisions are not so intimately tied. The legislative history on the function of subsection 434E is bare, but it was clearly intended to stand independently of subsection 608E1. It was enacted with the general disclosure provisions in 1971 as part of the original act, while subsection 608E1 was part of the 1974 amendments. Like the other disclosure provisions, subsection 434E could play a role in the enforcement of the expanded contribution and expenditure limitations included in the 1974 amendments, but it also has independent functions. Section 434E is part of Congress's effort to achieve total disclosure by reaching every kind of political activity in order to ensure that the voters are fully informed and to achieve through publicity the maximum deterrence to corruption and undue influence possible. The provision is responsive to the legitimate fear that efforts would be made, as they had been in the past, to avoid the disclosure requirements by routing financial support of candidates through avenues not explicitly covered by the general provisions of the Act. 2. Vagueness problems. In its effort to be all-inclusive, however, the provision raises serious problems of vagueness, particularly treacherous where, as here, the violation of its terms carries criminal penalties, and fear of incurring these sanctions may deter those who seek to exercise protected First Amendment rights. Section 434E applies to every person who makes contributions or expenditures. Contributions and expenditures are defined in parallel provisions in terms of the use of money or other valuable assets for the purpose of influencing the nomination or election of candidates for federal office. It is the ambiguity of this phrase that poses constitutional problems. Due process requires that a criminal statute provide adequate notice to a person of ordinary intelligence that his contemplated conduct is illegal, for no man shall be held criminally responsible for conduct which he could not reasonably understand to be prescribed. Where First Amendment rights are involved, an even greater degree of specificity is required. There is no legislative history to guide us in determining the scope of the critical phrase for the purpose of influencing. It appears to have been adopted without comment from earlier disclosure acts. Congress has voiced its wishes in most muted strains, leaving us to draw upon those common sense assumptions that must be made in determining direction without a compass. Where the constitutional requirement of definiteness is at stake, we have the further obligation to construe the statute if that can be done consistent with the legislature's purpose to avoid the shoals of vagueness. In enacting the legislation under review, Congress addressed broadly the problem of political campaign financing. It wished to promote full disclosure of campaign-oriented spending to ensure both the reality and the appearance of the purity and openness of the federal election process. Our task is to construe for the purpose of influencing, incorporated in subsection 434E through the definitions of contributions and expenditures, in a manner that precisely furthers this goal. In Part 1, we discussed what constituted a contribution for purposes of the contribution limitations set forth in 18 U.S.C. subsection 608B. We construed that term to include not only contributions made directly or indirectly to a candidate, political party, or campaign committee, and contributions made to other organizations or individuals but earmarked for political purposes, but also all expenditures placed in cooperation with or with the consent of a candidate, his agents, or an authorized committee of the candidate, candidate. The definition of contribution in subsection 431E for disclosure purposes parallels the definition in Title 18 almost word for word, and we construe the former provision as we have the latter. So defined, contributions have a sufficiently close relationship to the goals of the Act, for they are connected with the candidate or his campaign. When we attempt to define expenditure in a similarly narrow way, we encounter line drawing problems of the sort we faced in 18 USC subsection 608E1. Although the phrase for the purpose of influencing an election or nomination differs from the language used in subsection 608E1, it shares the same potential for encompassing both issue discussion and advocacy of a political result. The general requirement that political committees and candidates disclose their expenditures could raise similar vagueness problems, for a political committee is defined only in terms of amount of annual contributions and expenditures, and could be interpreted to reach groups engaged purely in issue discussion. The lower courts have construed the words political committee more narrowly. To fulfill the purposes of the Act, they need only encompass organizations that are under the control of a candidate or the major purpose of which is the nomination or election of a candidate. Expenditures of candidates and of political committees, so construed, can be assumed to fall within the core area sought to be addressed by Congress. They are, by definition, campaign related. But when the maker of the expenditure is not within these categories, when it is an individual other than a candidate or a group other than a political committee, the relation of the information sought to the purposes of the Act may be too remote. To ensure that the reach of subsection 434E is not impermissibly broad, we construe expenditure for purposes of that section in the same way we construed the terms of subsection 608E, to reach only funds used for communications that expressly advocate the election or defeat of a clearly identified candidate. This reading is directed precisely to that spending that is unambiguously related to the campaign of a particular federal candidate. In summary, subsection 434E, as construed, imposes independent reporting requirements on individuals and groups that are not candidates or political committees only in the following circumstances. 1. When they make contributions earmarked for political purposes or authorized or requested by a candidate or his agent to some person other than a candidate or political committee. And 2. When they make expenditures for communications that expressly advocate the election or defeat of a clearly identified candidate. Unlike 18 USC subsection 608E1, as construed, bears a sufficient relationship to a substantial governmental interest. As narrowed, subsection 434E, like subsection 608E1, does not reach all partisan discussion, for it only requires disclosure of those expenditures that expressly advocate a particular election result. This might have been fatal if the only purpose of subsection 434E were to stem corruption or its appearance by closing a loophole in the general disclosure requirements. But the disclosure provisions, including subsection 434E, serve another informational interest. And even as construed, subsection 434E increases the fund of information concerning those who support the candidates. It goes beyond the general disclosure requirements to shed the light of publicity on spending that is unambiguously campaign related but would not otherwise be reported because it takes the form of independent expenditures or of contributions to an individual or group not itself required to report the names of its contributors. By the same token, it is not fatal that subsection 434E encompasses purely independent expenditures uncoordinated with a particular candidate or his agent. The corruption potential of these expenditures may be significantly different, but the informational interest can be as strong as it is in coordinated spending, for disclosure helps voters to define more of the candidate's constituencies. Section 434E, as we have construed it, does not contain the infirmities of the provisions before the court in Talley v. California and Thomas v. Collins. The ordinance found wanting in Talley forbade all distribution of handbills that did not contain the name of the printer, author, or manufacturer, and the name of the distributor. The city urged that the ordinance was aimed at identifying those responsible for fraud, false advertising, and libel, but the court found that it was in no manner so limited. Here, as we have seen, the disclosure requirement is narrowly limited to those situations where the information sought has a substantial connection with the governmental interest sought to be advanced. Thomas held unconstitutional a prior restraint in the form of a registration requirement for labor organizers. The court found the state's interest insufficient to justify the restrictive effect of the statute. The burden imposed by subsection 434E is no prior restraint, but a reasonable and minimally restrictive method of furthering First Amendment values by opening the basic processes of our federal election system to public view. D. Thresholds. Appellant's third contention, based on alleged overbreadth, is that the monetary thresholds in the record keeping and reporting provisions lack a substantial nexus with the claimed governmental interests, for the amounts involved are too low even to attract the attention of the candidate, much less have a corrupting influence. The provisions contain two thresholds. Records are to be kept by political committees of the names and addresses of those who make contributions in excess of $10, and these records are subject to commission audit. If a person's contributions to a committee or candidate aggregate more than $100, his name and address, as well as his occupation and principal place of business, are to be included in reports filed by committees and candidates with the Commission, and made available for public inspection. The Court of Appeals rejected appellant's contention that these thresholds are unconstitutional. It found the challenge on First Amendment grounds to the $10 threshold to be premature, for it could discern no basis in the statute for authorizing disclosure outside the Commission, and hence no substantial inhibitory effect operating upon appellants. The $100 threshold was found to be within the reasonable latitude given the legislature as to where to draw the line. We agree. The $10 and $100 thresholds are indeed low. Contributors of relatively small amounts are likely to be especially sensitive to recording or disclosure of their political preferences. These strict requirements may well discourage participation by some citizens in the political process, a result that Congress hardly could have intended. Indeed, there is little in the legislative history to indicate that Congress focused carefully on the appropriate level at which to require recording and disclosure. Rather, it seems merely to have adopted the thresholds existing in similar disclosure laws since 1910. But we cannot require Congress to establish that it has chosen the highest reasonable threshold. The line is necessarily a judgmental decision, best left in the context of this complex legislation to congressional discretion. We cannot say on this bare record that the limits designated are wholly without rationality. We are mindful that disclosure serves informational functions, as well as the prevention of corruption and the enforcement of the contribution limitations. Congress is not required to set a threshold that is tailored only to the latter goals. In addition, the enforcement goal can never be well served if the threshold is so high that disclosure becomes equivalent to admitting violation of the contribution limitations. The $10 record-keeping threshold, in a somewhat similar fashion, facilitates the enforcement of the disclosure provisions by making it relatively difficult to aggregate secret contributions in amounts that surpass the $100 limit. We agree with the Court of Appeals that there is no warrant for assuming that public disclosure of contributions between $10 and $100 is authorized by the Act. Accordingly, we do not reach the question whether information concerning gifts of this size can be made available to the public without trespassing impermissibly on First Amendment rights. In summary, we find no constitutional infirmities in the record-keeping, reporting, and disclosure provisions of the Act. Public financing of presidential election campaigns. A series of statutes for the public financing of presidential election campaigns produced the scheme now found in subsection 6096 and subtitle H of the Internal Revenue Code of 1954. Both the District Court and the Court of Appeals sustained subtitle H against a constitutional attack. Appellants renew their challenge here, contending that the legislation violates the First and Fifth Amendments. We find no merit in their claims and affirm. Summary of Subtitle H. Section 9006 establishes a presidential election campaign fund financed from general revenues in the aggregate amount designated by individual taxpayers under subsection 6096, who, on their income tax returns, may authorize payment to the fund of $1 of their tax liability in the case of an individual return, or $2 in the case of a joint return. The fund consists of three separate accounts to finance: 1. Party nominating conventions, 2. General election campaigns, 3. Primary campaigns. Chapter 95 of Title 26, which concerns financing of party nominating conventions and general election campaigns, distinguishes among major, minor, and new parties. A major party is defined as a party whose candidate for president in the most recent election received 25% or more of the popular vote. A minor party is defined as a party whose candidate received at least 5% but less than 25% of the vote at the most recent election. All other parties are new parties, including both newly created parties and those receiving less than 5% of the vote in the last election. Major parties are entitled to $2 million to defray their National Committee Presidential Nominating Convention expenses, but must limit total expenditures to that amount and may not use any of this money to benefit a particular candidate or delegate. A minor party receives a portion of the major party entitlement determined by the ratio of the votes received by the party's candidate in the last election to the average of the votes received by the major party's candidates. The amounts given to the parties and the expenditure limit are adjusted for inflation using 1974 as the base year. No financing is provided for new parties, nor is there any express provision for financing independent candidates or parties not holding a convention. For expenses in the general election campaign, entitles each major party candidate to $20 million. This amount is also adjusted for inflation. To be eligible for funds, the candidate must pledge not to incur expenses in excess of the entitlement under subsection 9004A1, and not to accept private contributions except to the extent that the fund is insufficient to provide the full entitlement. Minor party candidates are also entitled to funding, again based on the ratio of the vote received by the party's candidate in the preceding election to the average of the major party candidates. Minor party candidates must certify that they will not incur campaign expenses in excess of the major party entitlement and that they will accept private contributions only to the extent needed to make up the difference between that amount and the public funding grant. New party candidates receive no money prior to the general election, but any candidate receiving 5% or more of the popular vote in the election is entitled to post-election payments according to the formula applicable to minor party candidates. Similarly, minor party candidates are entitled to post-election funds if they receive a greater percentage of the average major party vote than their party's candidate did in the preceding election. The amount of such payments is the difference between the entitlement based on the preceding election and that based on the actual vote in the current election. A further eligibility requirement for minor and new party candidates is that the candidate's name must appear on the ballot, or electors pledged to the candidate must be on the ballot in at least 10 states. Chapter 96 establishes a third account in the fund, the Presidential Primary Matching Payment Account. This funding is intended to aid campaigns by candidates seeking presidential nomination by a political party in primary elections. The threshold eligibility requirement is that the candidate raise at least $5,000 in each of 20 states, counting only the first $250 from each person contributing to the candidate. In addition, the candidate must agree to abide by the spending limits in subsection 9035. Funding is provided according to a matching formula. Each qualified candidate is entitled to a sum equal to the total private contributions received, disregarding contributions from any person to the extent that total contributions to the candidate by that person exceed $250. Payments to any candidate under Chapter 96 may not exceed 50% of the overall expenditure ceiling accepted by the candidate. Constitutionality of Subtitle H. Appellants argue that Subtitle H is invalid, 1, as contrary to the general welfare, and 2, because any scheme of public financing of election campaigns is inconsistent with the First Amendment, and 3, because Subtitle H invidiously discriminates against certain interests in violation of the Due Process Clause of the Fifth Amendment. We find no merit in these contentions. Appellant's general welfare contention erroneously treats the general welfare clause as a limitation upon congressional power. It is rather a grant of power, the scope of which is quite expansive, particularly in view of the enlargement of power by the necessary and proper clause. Congress has power to regulate presidential elections and primaries, and public financing of presidential elections as a means to reform the electoral process was clearly a choice within the granted power. It is for Congress to decide which expenditures will promote the general welfare. The power of Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution. Any limitations upon the exercise of that granted power must be found elsewhere in the Constitution. In this case, Congress was legislating for the general welfare to reduce the deleterious influence of large contributions on our political process, to facilitate communication by candidates with the electorate, and to free candidates from the rigors of fundraising. Whether the chosen means appear bad, unwise, or unworkable to us is irrelevant. Congress has concluded that the means are necessary and proper to promote the general welfare, and we thus decline to find this legislation without the grant of power in Article 1, subsection 8. Appellant's challenge to the dollar check-off provision, subsection 6096, fails for the same reason. They maintain that Congress is required to permit taxpayers to designate particular candidates or parties as recipients of their money, but the appropriation of the fund in subsection 9006 is like any other appropriation from the general revenue, except that its amount is determined by reference to the aggregate of the $1 and $2 authorization on taxpayers' income tax returns. This detail does not constitute the appropriation any less an appropriation by Congress. The fallacy of appellant's argument is therefore apparent. Every appropriation made by Congress uses public money in a manner to which some taxpayers object. Appellants next argue that by analogy to the religion clauses of the First Amendment, public financing of election campaigns, however meritorious, violates the First Amendment. We have, of course, held that the religion clauses, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, requires Congress and the states through the 14th Amendment to remain neutral in matters of religion. The government may not aid one religion to the detriment of others, or impose a burden on one religion that is not imposed on others, and may not even aid all religions. See here. But the analogy is patently inapplicable to our issue here. Although Congress shall make no law abridging the freedom of speech or of the press, Subtitle H is a congressional effort not to abridge, restrict, or censor speech, but rather to use public money to facilitate and enlarge public discussion and participation in the electoral process, goals vital to a self-governing people. Thus, Subtitle H furthers, not abridges, pertinent First Amendment values. Appellants argue, however, that as constructed, public financing invidiously discriminates in violation of the Fifth Amendment. We turn therefore to that argument. Equal protection analysis in the Fifth Amendment area is the same as that under the 14th Amendment. In several situations concerning the electoral process, the principle has been developed that restrictions on access to the electoral process must survive exacting scrutiny. The restriction can be sustained only if it furthers a vital governmental interest. That is achieved by a means that does not unfairly or unnecessarily burden either a minority party's or an individual candidate's equally important interest in the continued availability of political opportunity. These cases, however, dealt primarily with state laws requiring a candidate to satisfy certain requirements in order to have his name appear on the ballot. These were, of course, direct burdens not only on the candidate's ability to run for office, but also on the voter's ability to voice preferences regarding representative government and contemporary issues. In contrast, the denial of public financing to some presidential candidates is not restrictive of voters' rights and less restrictive of candidates. Subtitle H does not prevent any candidate from getting on the ballot or any voter from casting a vote for the candidate of his choice. The inability, if any, of minor party candidates to wage effective campaigns will derive not from lack of public funding, but from their inability to raise private contributions. Any disadvantage suffered by operation of the eligibility formula under subtitle H is thus limited to the claimed denial of the enhancement of opportunity to communicate with the electorate that the formula afford eligible candidates. But eligible candidates suffer a countervailing denial. As we more fully develop later, acceptance of public financing entails voluntary acceptance of an expenditure ceiling. Non eligible candidates are not subject to that limitation. Accordingly, we conclude that public financing is generally less restrictive of access to the electoral process than the ballot access regulations dealt with in prior cases. In any event, Congress enacted Subtitle H in furtherance of sufficiently important governmental interests and has not unfairly or unnecessarily burdened the political opportunity of any party or candidate. It cannot be gainsaid that public financing as a means of eliminating the improper influence of large private contributions furthers a significant governmental interest. In addition, the limits on contributions necessarily increase the burden of fundraising, and Congress properly regarded public financing as an appropriate means of relieving major party presidential candidates from the rigors of soliciting private contributions. The states have also been held to have important interests in limiting places on the ballot to those candidates who demonstrate substantial popular support. Congress's interest in not funding hopeless candidacies with large sums of public money necessarily justifies the withholding of public assistance from candidates without significant public support. Thus, Congress may legitimately require some preliminary showing of a significant modicum of support as an eligibility requirement for public funds. This requirement also serves the important public interest against providing artificial incentives to splintered parties and unrestrained factionalism. At the same time, Congress recognized the constitutional restraints against inhibition of the present opportunity of minor parties to become major political entities if they obtain widespread support. As the Court of Appeals said, provisions for public funding of presidential campaigns could operate to give an unfair advantage to established parties, thus reducing, to the nation's detriment, the potential fluidity of American political life. General election campaign financing. Appellants insist that Chapter 95 falls short of the constitutional requirement in that its provisions supply larger and equal sums to candidates of major parties, use prior vote levels as the sole criterion for pre-election funding, limit new party candidates to post-election funds, and deny any funds to candidates of parties receiving less than 5% of the vote. These provisions, it is argued, are fatal to the validity of the scheme because they work invidious discrimination against minor and new parties in violation of the Fifth Amendment. We disagree. As conceded by appellants, the Constitution does not require Congress to treat all declared candidates the same for public financing purposes. As we said in Jeunesse v. Fortson, there are obvious differences in kind between the needs and potentials of a political party with historically established broad support on the one hand and a new or small political organization on the other. Sometimes the grossest discrimination can lie in treating things that are different as though they were exactly alike, a truism well illustrated in Williams v. Rhodes. Since the presidential elections of 1856 and 1860, when the Whigs were replaced as a major party by the Republicans, no third party has posed a credible threat to the two major parties in presidential elections. Third parties have been completely incapable of matching the major party's ability to raise money and win elections. Congress was, of course, aware of this fact of American life, and thus was justified in providing both major parties full funding and all other parties only a percentage of the major party entitlement. Identical treatment of all parties, on the other hand, would not only make it easy to raid the United States Treasury, it would also artificially foster the proliferation of splinter parties. The Constitution does not require the government to finance the efforts of every nascent political group, merely because Congress chose to finance the efforts of the major parties. Furthermore, appellants have made no showing that the election funding plan disadvantages non-major parties by operating to reduce their strength below that attained without any public financing. First, such parties are free to raise money from private sources, and by our holding today, new parties are freed from any expenditure limits, although admittedly those limits may be a largely academic matter to them. But since any major party candidate accepting public financing of a campaign voluntarily assents to a spending ceiling, other candidates will be able to spend more in relation to the major party candidates. The relative position of minor parties that do qualify to receive some public funds because they received 5% of the vote in the previous presidential election is also enhanced. Public funding for candidates of major parties is intended as a substitute for private contributions, but for minor party candidates, such assistance may be viewed as a supplement to private contributions since these candidates may continue to solicit private funds up to the applicable spending limit. Thus, we conclude that the general election funding system does not work an invidious discrimination against candidates of non major parties. Appellants challenge reliance on the vote in past elections as the basis for determining eligibility. That challenge is foreclosed, however, by our holding in Jeunesse v. Fortson. That popular vote totals in the last election are a proper measure of public support, and Congress was not obliged to select instead from among appellants' suggested alternatives. Congress could properly regard the means chosen as preferable, since the alternative of petition drives presence, cost, and administrative problems in validating signatures, and the alternative of opinion polls might be thought inappropriate since it would involve a government agency in the business of certifying polls or conducting its own investigation of support for various candidates, in addition to serious problems with reliability. Appellants next argue, relying on the ballot access decisions of this court, that the absence of any alternative means of obtaining pre election funding renders the scheme unjustifiably restrictive of minority political interests. Appellants' reliance on the ballot access decisions is misplaced. To be sure, the regulation sustained in Jeunesse v. Fortson, for example, incorporated alternative means of qualifying for the ballot, and the lack of an alternative was a defect in the scheme struck down in Lubin v. Panish. To suggest, however, that the constitutionality of Subtitle H therefore hinges solely on whether some alternative is afforded overlooks the rationale of the operative constitutional principles. Our decisions finding a need for an alternative means turn on the nature and extent of the burden imposed in the absence of available alternatives. We have earlier stated our view that Chapter 95 is far less burdensome upon the restrictive of and is far less burdensome upon and restrictive of constitutional rights than the regulations involved in the ballot access cases. Moreover, expenditure limits for major parties and candidates may well improve the chances of non-major parties and their candidates to receive funds and increase their spending. Any risk of harm to minority interests is speculative due to our present lack of knowledge of the practical effects of public financing and cannot overcome the force of the governmental interests against use of public money to foster frivolous candidacies, create a system of splintered parties, and encourage unrestrained factionalism. Appellants' reliance on the alternative means analyses of the ballot access cases generally fails to recognize a significant distinction from the instant case. The primary goal of all candidates is to carry on a successful campaign by communicating to the voters persuasive reasons for electing them. In some of the ballot access cases, the states afforded candidates alternative means for qualifying for the ballot, a step in any campaign that, with rare exceptions, is essential to successful effort. Chapter 95 conceitedly provides only one method of obtaining pre-election financing. Such funding is, however, not as necessary as being on the ballot. Plainly, campaigns can be successfully carried out by means other than public financing. They have been up to this date, and this avenue is still open to all candidates. And after all, the important achievements of minority political groups in furthering the development of American democracy were accomplished without the help of public funds. Thus, the limited participation or non-participation of non-majority parties or candidates in the public funding does not unconstitutionally disadvantage them. Of course, non-major parties and their candidates may qualify for post-election participation in public funding, and in that sense, the claimed discrimination is not total. Appellants contend, however, that the benefit of any such participation is illusory due to subsection 9004C, which bars the use of the money for any purpose other than paying campaign expenses or repaying loans that had been used to defray such expenses. The only meaningful use for post-election funds is thus to repay loans, but loans, except from national banks, are contributions subject to the general limitations on contributions. Further, they argue, loans are not readily available to non-major parties or candidates before elections to finance their campaigns. Availability of post-election funds, therefore, assertedly gives them nothing. But in the nature of things, the willingness of lenders to make loans will depend upon the pre-election probability that the candidate and his party will attract 5% or more of the voters. When a reasonable prospect of such support appears, the party and candidate may be an acceptable loan risk since the prospect of post-election participation in public funding will be good. Finally, appellants challenge the validity of the 5% threshold requirement for general election funding. They argue that since most state regulations governing ballot access have threshold requirements well below 5%, and because in their view the 5% requirement here is actually stricter than that upheld in Jeunesse v. Fortson, the requirement is unreasonable. We have already concluded that the restriction under Chapter 95 is generally less burdensome than ballot access regulations. Further, the Georgia provision sustained in Jeunesse required the candidate to obtain the signatures of 5% of all eligible voters without regard to party. To be sure, the public funding formula does not permit anyone who voted for another party in the last election to be part of a candidate's 5%. But under Chapter 95, a presidential candidate needs only 5% or more of the actual vote, not the larger universe of eligible voters. As a result, we cannot say that Chapter 95 is numerically more or less restrictive than the regulation in Jeunesse. In any event, the choice of the percentage requirement that best accommodates the competing interests involved was for Congress to make. Without any doubt, a range of formulations would sufficiently protect the public fisc and not foster factionalism, and would also recognize the public interest in the fluidity of our political affairs. We cannot say that Congress's choice falls without the permissible range. Nominating convention financing. The foregoing analysis and reasoning sustaining general election funding apply in large part to convention funding under Chapter 95 and suffice to support our rejection of appellant's challenge to these provisions. Funding of party conventions has increasingly been derived from large private contributions, and the governmental interest in eliminating this reliance is as vital as in the case of private contributions to individual candidates. The expenditure limitations on major parties participating in public financing enhance the ability of non-major parties to increase their spending relative to the major parties. Further, in soliciting private contributions to finance conventions, parties are not subject to the $1,000 contribution limit pertaining to candidates. We therefore conclude that appellant's constitutional challenge to the provisions for funding nominating conventions must also be rejected. Primary election campaign financing. Appellant's final challenge is to the constitutionality of Chapter 96, which provides funding of primary campaigns. They contend that these provisions are constitutionally invalid, 1, because they do not provide funds for candidates not running in political primaries, and 2, because the eligibility formula actually increases the influence of money on the electoral process. In not providing assistance to candidates who do not enter party primaries, Congress has merely chosen to limit at this time the reach of the reforms encompassed in Chapter 96. This Congress could do without constituting the reforms a constitutionally invidious discrimination. This Congress could do without constituting the reforms a constitutionally invidious discrimination. The governing principle was stated in Katzenbach v. Morgan. In deciding the constitutional propriety of the limitations in such a reform measure, we are guided by the familiar principles that a statute is not invalid under the Constitution because it might have gone farther than it did. That a legislature need not strike at all evils at the same time, and that reform may take one step at a time, addressing itself to the phase of the problem which seems most acute to the legislative mind. The choice to limit matching funds to candidates running in primaries may reflect that concern about large private contributions to candidates centered on primary races, and that there is no historical evidence of similar abuses involving contributions to candidates who engage in petition drives to qualify for state ballots. Moreover, assistance to candidates and non major parties forced to resort to petition drives to gain ballot access implicates the policies against fostering frivolous candidacies, creating a system of splintered parties, and encouraging unrestrained factionalism. The eligibility requirements in Chapter 96 are surely not an unreasonable way to measure popular support for a candidate, accomplishing the objective of limiting subsidization to those candidates with a substantial chance of being nominated. Counting only the first $250 of each contribution for eligibility purposes requires candidates to solicit small contributions from numerous people. Requiring the money to come from citizens of a minimum number of states eliminates candidates whose appeal is limited geographically. A president is elected not by popular vote, but by winning the popular vote in enough states to have a majority in the Electoral College. We also reject as without merit appellant's argument that the matching formula favors wealthy voters and candidates. The thrust of the legislation is to reduce financial barriers and to enhance the importance of smaller contributions. Some candidates undoubtedly could raise large sums of money and thus have little need for public funds, but candidates with lesser fundraising capabilities will gain substantial benefits from matching funds. In addition, one eligibility requirement for matching funds is acceptance of an expenditure ceiling, and candidates with little fundraising ability will be able to increase their spending relative to candidates capable of raising large amounts in private funds. For the reasons stated, we reject appellant's claims that subtitle H is facially unconstitutional. Severability. The only remaining issue is whether our holdings invalidating 18 USC subsections 608A, C, and E1 require the conclusion that subtitle H is unconstitutional. There is, of course, a relationship between the spending limits in subsection 608C and the public financing provisions. The expenditure limits accepted by a candidate to be eligible for public funding are identical to the limits in subsection 608C, but we have no difficulty in concluding that subtitle H is severable, unless it is evident that the legislature would not have enacted those provisions which are within its power, independently of that which is not. The invalid part may be dropped if what is left is fully operative as a law. Our discussion of what is left leaves no doubt that the value of public financing is not dependent on the existence of a generally applicable expenditure limit. We therefore hold subtitle H severable from those portions of the legislation today held constitutionally infirm. The Federal Election Commission. The 1974 amendments to the Act create an 8-member Federal Election Commission and invest in it primary and substantial responsibility for administering and enforcing the Act. The question that we address in this portion of the opinion is whether, in view of the manner in which a majority of its members are appointed, the Commission may, under the Constitution, exercise the powers conferred upon it. We find it unnecessary to parse the complex statutory provisions in order to sketch the full sweep of the Commission's authority. It will suffice for present purposes to describe what appear to be representative examples of its various powers. Chapter 14 of Title II makes the Commission the principal repository of the numerous reports and statements which are required by that chapter to be filed by those engaging in the regulated political activities. Its duties under subsection 438A with respect to these reports and statements include filing and indexing, making them available for public inspection, preservation, and auditing, and field investigations. It is directed to serve as a national clearinghouse for information in respect to the administration of elections. Beyond these record-keeping, disclosure, and investigative functions, however, the Commission is given extensive rulemaking and adjudicative powers. Its duty under subsection 438A10 is to prescribe suitable rules and regulations to carry out the provisions of Chapter 14. Under subsection 437D(a)(8), the Commission is empowered to make such rules as are necessary to carry out the provisions of this Act. Section 437D(a)(9) authorizes it to formulate general policy with respect to the administration of this act and enumerated sections of Title 18's Criminal Code, as to all of which provisions the Commission has primary jurisdiction with respect to their civil enforcement. The Commission is authorized under subsection 437F(a) to render advisory opinions with respect to activities possibly violating the Act, the Title 18 sections, or the campaign funding provisions of Title 26, the effect of which is that, notwithstanding any other provision of law, any person with respect to whom an advisory opinion is rendered, who acts in good faith in accordance with the provisions and findings thereof, shall be presumed to be in compliance with the statutory provision with respect to which such advisory opinion is rendered. In the course of administering the provisions for presidential campaign financing, the Commission may authorize convention expenditures which exceed the statutory limits. The Commission's enforcement power is both direct and wide-ranging. It may institute a civil action for 1. Injunctive or other relief against any acts or practices which constitute or will constitute a violation of this Act. 2. Declaratory or injunctive relief, as may be appropriate to implement or construe any provisions of Chapter 95 of Title 26, governing administration of funds for presidential election campaigns and national party conventions. And 3. Such injunctive relief is appropriate to implement any provision of Chapter 96 of Title 26 governing the payment of matching funds for presidential primary campaigns. If, after the Commission's post-disbursement audit of candidates receiving payments under Chapter 95 or 96, it finds an overpayment, it is empowered to seek repayment of all funds due the Secretary of the Treasury. In no respect do the foregoing civil actions require the concurrence of or participation by the Attorney General. Conversely, the decision not to seek a judicial relief in the above respects would appear to rest solely with the Commission. With respect to the referenced Title 18 sections, subsection 437G(a)(7) provides that if, after notice and opportunity for a hearing before it, the Commission finds an actual or threatened criminal violation, the Attorney General, upon request by the Commission, shall institute a civil action for relief. Finally, as additional enforcement authority, subsection 456A authorizes the Commission, after notice and opportunity for hearing, to make a finding that a person, while a candidate for federal office, failed to file a required report of contributions or expenditures. If that finding is made within the applicable limitations period for prosecutions, the candidate is thereby disqualified from becoming a candidate in any future election for federal office for a period of time beginning on the date of such finding and ending 1 year after the expiration of the term of the federal office for which such person was a candidate. The body in which this authority is reposed consists of 8 members. The Secretary of the Senate and the Clerk of the House of Representatives are ex officio members of the Commission without the right to vote. 2 members are appointed by the President pro tempore of the Senate upon the recommendations of the Majority Leader of the Senate and the Minority Leader of the Senate. 2 more are to be appointed by the Speaker of the House of Representatives, likewise upon the recommendations of its respective majority and minority leaders. The remaining 2 members are appointed by the President. Each of the 6 voting members of the Commission must be confirmed by the majority of both houses of Congress, and each of the 3 appointing authorities is forbidden to choose both of their appointees from the same political party. Ripeness. Appellants argue that given the Commission's extensive powers, the method of choosing its members under subsection 437C(a)(1) runs afoul of the separation of powers embedded in the Constitution, and urge that as presently constituted, the Commission's existence be held unconstitutional by this Court. Before embarking on this or any related inquiry, however, we must decide whether these issues are properly before us. Because of the Court of Appeal's emphasis on lack of ripeness of the issue relating to the method of appointment of the members of the Commission, we find it necessary to focus particularly on that consideration in this section of our opinion. We have recently recognized the distinction between jurisdictional limitations imposed by Article 3 and problems of prematurity and abstractness that may prevent adjudication in all but the exceptional case. In Regional Rail Reorganization Act cases, we stated that ripeness is peculiarly a question of timing, and therefore the passage of months between the time of the decision of the Court of Appeals and our present ruling is of itself significant. We likewise observed in the Reorganization Act cases thus occurrence of the conveyance allegedly violative of Fifth Amendment rights is in no way hypothetical or speculative. Where the inevitability of the operation of a statute against certain individuals is patent, it is irrelevant to the existence of a justiciable controversy that there will be a time delay before the disputed provisions will come into effect. The Court of Appeals held that of the 5 specific certified questions directed at the Commission's authority, only its power to render advisory opinions and to authorize excessive convention expenditures were ripe for adjudication. The Court held that the remaining aspects of the Commission's authority could not be adjudicated because, in its present stance, this litigation does not present the Court with the concrete facts that are necessary to an informed decision. Since the entry of judgment by the Court of Appeals, the Commission has undertaken to issue rules and regulations under the authority of subsection 438A10. While many of its other functions remain as yet unexercised, the date of their all but certain exercise is now closer by several months than it was at the time the Court of Appeals ruled. Congress was understandably most concerned with obtaining a final adjudication of as many issues as possible litigated pursuant to the provisions of subsection 437H. Thus, in order to decide the basic question whether the Act's provision for appointment of the members of the Commission violates the Constitution, we believe we are warranted in considering all of those aspects of the Commission's authority which have been presented by the certified questions. Party litigants with sufficient concrete interests at stake may have standing to raise constitutional questions of separation of powers with respect to an agency designated to adjudicate their rights. In Glidden, of course, the challenged adjudication had already taken place, whereas in this case, appellant's claim is of impending future rulings and determinations by the Commission. But this is a question of ripeness, rather than lack of case or controversy, under Article 3, and for the reasons to which we have previously adverted, we hold that appellant's claims, as they bear upon the method of appointment of the Commission's members, may be presently adjudicated. The merits. Appellants urge that since Congress has given the Commission wide-ranging rulemaking and enforcement powers with respect to the substantive provisions of the Act, Congress is precluded under the principle of separation of powers from vesting in itself the authority to appoint those who will exercise such authority. Their argument is based on the language of Article 2, subsection 2, clause 2 of the Constitution, which provides, in pertinent part, as follows: the President shall nominate, and by and with the advice and consent of the Senate, shall appoint all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. Appellant's argument is that this provision is the exclusive method by which those charged with executing the laws of the United States may be chosen. Congress, they assert, cannot have it both ways. If the legislature wishes the Commission to exercise all of the conferred powers, then its members are in fact officers of the United States and must be appointed under the Appointments Clause. But if Congress insists upon retaining the power to appoint, then the members of the Commission may not discharge those many functions of the Commission which can be performed only by officers of the United States, as that term must be construed within the doctrine of separation of powers. Appellee Commission and amici, in support of the Commission, urge that the framers of the Constitution while mindful of the need for checks and balances among the three branches of the national government, had no intention of denying to the legislative branch authority to appoint its own officers. Congress, either under the Appointments Clause or under its grants of substantive legislative authority and the Necessary and Proper Clause in Article 1, is in their view empowered to provide for the appointment to the Commission in the manner which it did because the Commission is performing appropriate legislative functions. The majority of the Court of Appeals recognized the importance of the doctrine of separation of powers, which is at the heart of our Constitution, and also recognized the principle enunciated in Springer v. Philippine Islands, that the legislative branch may not exercise executive authority by retaining the power to appoint those who will execute its laws. But it described appellant's argument based upon Article 2, subsection 2, clause 2, as strikingly syllogistic, and concluded that Congress had sufficient authority under the necessary and proper clause of Article 1 of the Constitution not only to establish the Commission, but to appoint the Commission's members. As we have earlier noted, it upheld the constitutional validity of congressional vesting of certain authority in the Commission, and concluded that the question of the constitutional validity of the vesting of its remaining functions was not yet ripe for review. The three dissenting judges in the Court of Appeals concluded that the method of appointment for the Commission did violate the doctrine of separation of powers. Separation of powers. We do not think appellant's arguments based upon Article 2, subsection 2, clause 2 of the Constitution may be so easily dismissed, as did the majority of the Court of Appeals. Our inquiry of necessity touches upon the fundamental principles of the government established by the framers of the Constitution, and all litigants and all of the courts which have addressed themselves to the matter start on common ground in the recognition of the intent of the framers that the powers of the three great branches of the national government be largely separate from one another. James Madison, writing in the Federalist No. 47, defended the work of the framers against the charge that these three governmental powers were not entirely separate from one another in the proposed Constitution. He asserted that while there is some admixture, the Constitution was nonetheless true to Montesquieu's well-known maxim that the legislative, executive, and judicial departments ought to be separate and distinct. The reasons on which Montesquieu grounds his maxim are a further demonstration of his meaning. When the legislative and executive powers are united in the same person or body, says he, there can be no liberty because apprehensions may arise lest the same monarch or senate should enact tyrannical laws to execute them in a tyrannical manner. Again, were the power of judging joined with the legislative, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be the legislator. Were it joined to the executive power, the judge might behave with all the violence of an oppressor. Some of these reasons are more fully explained in other passages, but briefly stated as they are here, they sufficiently establish the meaning which we have put on this celebrated maxim of this celebrated author. Yet it is also clear from the provisions of the Constitution itself, and from the Federalist Papers, that the Constitution by no means contemplates total separation of each of these three essential branches of government. The President is a participant in the lawmaking process by virtue of his authority to veto bills enacted by Congress. The Senate is a participant in the appointive process by virtue of its authority to refuse to confirm the persons nominated to office by the President. The men who met in Philadelphia in the summer of 1787 were practical statesmen, experienced in politics, who viewed the principle of separation of powers as a vital check against tyranny, but they likewise saw that a hermetic sealing off of the three branches of government from one another would preclude the establishment of a nation capable of governing itself effectively. Mr. Chief Justice Taft, writing for the court in Hampton and Company versus United States, after stating the general principle of separation of powers found in the United States Constitution, went on to observe, the rule is that in the actual administration of the government, Congress or the legislature should exercise the legislative power, the president or the state executive, the governor, the executive power, and the courts or the judiciary the judicial power. And in carrying out that constitutional division into three branches, it is a breach of the national fundamental law if Congress gives up its legislative power and transfers it to the president or to the judicial branch. or if by law it attempts to invest itself or its members with either executive power or judicial power. This is not to say that the three branches are not coordinate parts of one government, and that each in the field of its duties may not invoke the action of the two other branches, insofar as the action invoked shall not be an assumption of the constitutional field of action of another branch. In determining what it may do in seeking assistance from another branch, the extent and character of that assistance must be fixed according to common sense and the inherent necessities of the governmental coordination. More recently, Mr. Justice Jackson, concurring in the opinion and the judgment of the court in Youngstown Sheet and Tube Company versus Sawyer, succinctly characterizes this understanding. While the Constitution diffuses power the better to secure liberty, it also contemplates that practice will integrate the dispersed powers into a workable government. It enjoins upon its branches separateness but interdependence, autonomy but reciprocity. The framers regarded the checks and balances that they had built into the tripartite federal government as a self-executing safeguard against the encroachment or aggrandizement of one branch at the expense of the other. As Madison put it in Federalist Number 51, this policy of supplying, by opposite and rival interests, the defect of better motives might be traced through the whole system of human affairs, private as well as public. We see it particularly displayed in all the subordinate distributions of power, where the constant aim is to divide and arrange the several offices in such a manner as that each may be a check on the other, that the private interest of every individual may be a sentinel over the public rights. These inventions of prudence cannot be less requisite in the distribution of the supreme powers of the state. This court has not hesitated to enforce the principle of separation of powers embodied in the Constitution when its application has proved necessary for the decisions of cases or controversies properly before it. The court has held that executive or administrative duties of a non-judicial nature may not be imposed on judges holding office under Article 3 of the Constitution. The court has held that the president may not execute and exercise legislative authority belonging only to Congress. In the course of its opinion in that case, the court said, "In the framework of our Constitution, the president's power to see that the laws are faithfully executed refutes the idea that he is to be a lawmaker. The Constitution limits his functions in the lawmaking process to the recommending of laws he thinks wise and the vetoing of laws he thinks bad. And the Constitution is neither silent nor equivocal about who shall make laws which the president is to execute. The first section of the first article says that all legislative powers herein granted shall be vested in a Congress of the United States." More closely in point to the facts of the present case is this court's decision in Springer v. Philippine Islands, where the court held that the legislature of the Philippine Islands could not provide for legislative appointment to executive agencies. The Appointments Clause. The principle of separation of powers was not simply an abstract generalization in the minds of the framers, it was woven into the document that they drafted in Philadelphia in the summer of 1787. Article 1, subsection 1 declares, "All legislative powers herein granted shall be vested in a Congress of the United States." Article 2, subsection 1 vests the executive power in a President of the United States of America. And Article 3, subsection 1 declares that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The further concern of the framers of the Constitution with maintenance of the separation of powers is found in the so-called ineligibility or incompatibility clauses contained in Article 1, subsection 6. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time. And no person holding any office under the United States shall be a member of either house during his continuance in office. It is in the context of these cognate provisions of the document that we must examine the language of Article 2, subsection 2, clause 2, which appellants contend provides the only authorization for appointment of those to whom substantial executive or administrative authority is given by statute. Because of the importance of its language, we again set out the provision. The President shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law, but the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The Appointments Clause could, of course, be read as merely dealing with etiquette or protocol in describing officers of the United States, but the drafters had a less frivolous purpose in mind. This conclusion is supported by language from United States v. Germain. The Constitution, for purposes of appointment, very clearly divides all its officers into two classes. The primary class requires a nomination by the President and confirmation by the Senate. But foreseeing that when offices became numerous and sudden removals necessary, this mode might be inconvenient. It was provided that, in regard to officers inferior to those specially mentioned, Congress might by law vest their appointment in the President alone, in the courts of law, or in the heads of departments. That all persons who can be said to hold an office under the government about to be established under the Constitution were intended to be included within one or the other of these modes of appointment, there can be but little doubt. We think that the term officers of the United States, as used in Article 2, defined to include all persons who can be said to hold an office under the government. In United States v. Germain, is a term intended to have substantive meaning. We think its fair import is that any appointee exercising significant authority pursuant to the laws of the United States is an officer of the United States, and must therefore be appointed in the manner prescribed by subsection 2, clause 2 of that article. If all persons who can be said to hold an office under the government about to be established under the Constitution were intended to be included within one or the other of these modes of appointment, it is difficult to see how the members of the Commission may escape inclusion. If a postmaster first class and the clerk of a court are inferior officers of the United States within the meaning of the Appointments Clause, as they are, surely the commissioners before us are at the very least such inferior officers within the meaning of that clause. Although two members of the commission are initially selected by the president, his nominations are subject to confirmation not merely by the Senate, but by the House of Representatives as well. The remaining four voting members of the commission are appointed by the president pro tempore of the Senate and by the Speaker of the House. While the second part of the clause authorizes Congress to vest the appointment of the officers described in that part in the courts of law or in the heads of departments, neither the Speaker of the House nor the President pro tempore of the Senate comes within this language. The phrase heads of departments, used as it is in conjunction with the phrase courts of law, suggests that the departments referred to are themselves in the executive branch or at least have some connection with that branch. While the clause expressly authorizes Congress to vest the appointment of certain officers in the courts of law, the absence of similar language to include Congress must mean that neither Congress nor its officers were included within the language heads of departments in this part of Clause 2. Thus, with respect to 4 of the 6 voting members of the Commission, neither the President, the head of any department, nor the judiciary has any voice in their selection. The Appointments Clause specifies the method of appointment only for officers of the United States whose appointment is not otherwise provided for in the Constitution, but there is no provision of the Constitution remotely providing any alternative means for the selection of the members of the Commission or for anybody like them. Appellee Commission has argued, and the Court of Appeals agreed, that the Appointments Clause of Article 2 should not be read to exclude the inherent powers of Congress to appoint its own officers to perform functions necessary to that body as an institution. But there is no need to read the Appointments Clause contrary to its plain language in order to reach the result sought by the Court of Appeals. Article 1, subsection 3, clause 5 expressly authorizes the selection of the President pro tempore of the Senate, and subsection 2, clause 5 of that article provides for the selection of the Speaker of the House. Ranking non-members, such as the Clerk of the House of Representatives, are elected under the internal rules of each House, and are designated by statute as officers of the Congress. There is no occasion for us to decide whether any of these members These member officers are officers of the United States, whose appointment is otherwise provided for within the meaning of the Appointments Clause, since even if they were such officers, their appointees would not be. Contrary to the fears expressed by the majority of the Court of Appeals, nothing in our holding with respect to Article 2, subsection 2, clause 2 will deny to Congress all power to appoint its own inferior officers to carry out appropriate legislative functions. Appellee Commission and amici contend somewhat obliquely that because the framers had no intention of relegating Congress to a position below that of the co-equal judicial and executive branches of the national government, the Appointments Clause must somehow be read to include Congress or its officers as among those in whom the appointment power may be vested. But the debates of the Constitutional Convention and the Federalist Papers are replete with expressions of fear that the legislative branch of the national government will aggrandize itself at the expense of the other two branches. The debates during the convention and the evolution of the draft version of the Constitution seem to us to lend considerable support to our reading of the language of the Appointments Clause itself. An interim version of the draft constitution had vested in the Senate the authority to appoint ambassadors, public ministers, and judges of the Supreme Court, and the language of Article 2, as finally adopted, is a distinct change in this regard. We believe that it was a deliberate change made by the framers with the intent to deny Congress any authority itself to appoint those who were officers of the United States. The debates on the floor of the convention reflect at least in part the way the change came about. On Monday, August 6, 1787, the Committee on Detail, to which had been referred the entire draft of the Constitution, reported its draft to the Convention, including the following two articles that bear on the question before us. Article 9, subsection 1. The Senate of the United States shall have power to appoint ambassadors and judges of the Supreme Court. Article 10, subsection 2, the President shall commission all the officers of the United States and shall appoint officers in all cases not otherwise provided for by this Constitution. It will be seen from a comparison of these two articles that the appointment of ambassadors and judges of the Supreme Court was confided to the Senate, and that the authority to appoint, not merely nominate, but to actually appoint all other officers was reposed in the President. During a discussion of a provision in the same draft from the Committee on Detail, which provided that the Treasurer of the United States should be chosen by both houses of Congress, Mr. Reed moved to strike out that clause, leaving the appointment of the Treasurer as of other officers to the executive. Opposition to Reed's motion was based not on objection to the principle of executive appointment, but on the particular nature of the office of the Treasurer. On Thursday, August 23rd, the convention voted to insert after the word ambassadors in the text of draft Article 9 the words "and other public ministers." Immediately afterwards, the section as amended was referred to the Committee of Five. The following day, the convention took up Article 10. Roger Sherman objected to the draft language of subsection 2 because it conferred too much power on the President, and proposed to insert after the words "not otherwise provided for by this Constitution" the words "or by law." This motion was defeated by a vote of 9 states to 1. On September 3rd, the convention debated the ineligibility and incompatibility clauses, which now appear in Article 1, and made the ineligibility clause somewhat less stringent. Meanwhile, on Friday, August 31st, a motion had been carried without opposition to refer such parts of the Constitution as had been postponed or not acted upon to a committee of 11. Such reference carried with it both Articles 9 and 10. The following week, the Committee of 11 made its report to the Convention, in which the present language of Article 2, subsection 2, clause 2, dealing with the authority of the President to nominate, is found virtually word for word as subsection 4 of Article 10. The same committee also reported a revised article concerning the legislative branch to the Convention. The changes are obvious. In the final version, the Senate is shorn of its power to appoint ambassadors and judges of the Supreme Court. The President is given not the power to appoint public officers of the United States, but only the right to nominate them, and a provision is inserted by virtue of which Congress may require Senate confirmation of his nominees. It would seem a fair surmise that a compromise had been made, but no change was made in the concept of the term officers of the United States, which, since it had first appeared in Article 10, had been taken by all concerned to embrace all appointed officials exercising responsibility under the public laws of the nation. Appellee Commission and amici urge that because of what they conceive to be the extraordinary authority reposed in Congress to regulate elections, this case stands on a different footing than if Congress had exercised its legislative authority in another field. There is, of course, no doubt that Congress has express authority to regulate congressional elections by virtue of the power conferred in Article 1, subsection 4. This court has also held that it has very broad authority to prevent corruption in national presidential elections. But Congress has plenary authority in all areas in which it has substantive legislative jurisdiction, so long as the exercise of that authority does not offend some other constitutional restriction. We see no reason to believe that the authority of Congress over federal election practices is of such a wholly different nature from the other grants of authority to Congress that it may be employed in such a manner as to offend well-established constitutional restrictions stemming from the separation of powers. The position that because Congress has been given explicit and plenary authority to regulate a field of activity, it must therefore have the power to appoint those who are to administer the regulatory statute is both novel and contrary to the language of the Appointments Clause. Unless their selection is elsewhere provided for, all officers of the United States are to be appointed in accordance with the clause. Principal officers are selected by the President with the advice and consent of the Senate. Inferior officers Congress may allow to be appointed by the President alone, by the heads of departments, or by the judiciary. No class or type of officer is excluded because of its special functions. The President appoints judicial as well as executive officers. Neither has it been disputed, and apparently it is not now disputed, that the clause controls the appointment of the members of a typical administrative agency, even though its functions, as this court recognized in Humphrey's Executor v. United States, may be predominantly quasi-judicial and quasi-legislative, rather than executive. The court in that case carefully emphasized that although the members of such agencies were to be independent of the executive in their day-to-day operations, the executive was not excluded from selecting them. Appellees argue that the legislative authority conferred upon the Congress in Article 1, subsection 4, to regulate the times, places, and manner of holding elections for senators and representatives is augmented by the provision in subsection 5 that each House shall be the judge of the elections, returns, and qualifications of its own members. Section 5 confers, however, not a general legislative power upon the Congress, but rather a power judicial in character upon each House of the Congress. The power of each House to judge whether one claiming election as senator or representative has met the requisite qualifications cannot reasonably be translated into a power granted to the Congress itself to impose substantive qualifications on the right to so hold such office. Whatever power Congress may have to legislate, such qualifications must derive from subsection 4 rather than subsection 5 of Article 1. Appellees also rely on the 12th Amendment to the Constitution, insofar as the authority of the Commission to regulate practices in connection with the presidential election is concerned. This amendment provides that certificates of the votes of the electors be sealed and directed to the President of the Senate, and that the President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall then be counted. The method by which Congress resolved the celebrated disputed Hayes-Tilden election of 1876, reflected in 19 Statute 227, supports the conclusion that Congress viewed this amendment as conferring upon its two houses the same sort of power, judicial in character, as was conferred upon each house by Article 1, subsection 5, with respect to elections of its own members. We are also told by appellees and amici that Congress had good reason for not vesting in a commission composed wholly of presidential appointees the authority to administer the act, since the administration of the act would undoubtedly have a bearing on any incumbent president's campaign for re-election. While one cannot dispute the basis for this sentiment as a practical matter, it would seem that those who sought to challenge incumbent congressmen might have equally good reason to fear a commission which was unduly responsive to members of Congress whom they were seeking to unseat. But such fears, however rational, do not by themselves warrant a distortion of the framers' work. Appellee Commission and amici finally contend, and the majority of the Court of Appeals agreed with them, that whatever shortcomings the provision for the appointment of members of the Commission might have under Article 2, Congress had ample authority under the Necessary and Proper Clause of Article 1 to effectuate this result. We do not agree. The proper inquiry when considering the Necessary and Proper Clause is not the authority of Congress to create an office or a commission, which is broad indeed, but rather its authority to provide that its own officers may make appointments to such office or commission. So framed, the claim that Congress may provide for this manner of appointment under the Necessary and Proper Clause of Article 1 stands on no better footing than the claim that it may provide for such manner of appointment because of its substantive authority to regulate federal elections. Congress could not, merely because it concluded that such a measure was necessary and proper to the discharge of its substantive legislative authority, pass a bill of attainder or ex post facto law contrary to the prohibitions contained in subsection 9 of Article 1. No more may it vest in itself or in its officers the authority to appoint officers of the United States when the Appointments Clause, by clear implication, prohibits it from doing so. The trilogy of cases from this court dealing with the constitutional authority of Congress to circumscribe the President's power to remove officers of the United States is entirely consistent with this conclusion. In Myers v. United States, the court held that Congress could not, by statute, divest the President of the power to remove an officer in the executive branch whom he was initially authorized to appoint. In explaining its reasoning in that case, the court said, "The vesting of the executive power in the President was essentially a grant of the power to execute the laws. But the President alone and unaided could not execute the laws. He must execute them by the assistance of subordinates, and he is charged specifically to take care that they be faithfully executed. The reasonable implication, even in the absence of express words, was that as part of his executive power, he should select those who were to act for him under his direction in the execution of the laws." Our conclusion on the merits, sustained by the arguments before stated, is that Article 2 grants to the President the executive power of the government, i.e., the general administrative control of those executing the laws, including the power of appointment and removal of executive officers, a conclusion confirmed by his obligation to take care that the laws be faithfully executed. In the later case of Humphrey's executor, where it was held that Congress could circumscribe the President's power to remove members of independent regulatory agencies, the court was careful to note that it was dealing with an agency intended to be independent of executive authority except in its selection, which applied the holding Wiener v. United States, which applied the holding in Humphrey's executor to a member of the War Claims Commission, did not question in any respect that members of independent agencies are not independent of the executive with respect to their appointments. This conclusion is buttressed by the fact that Mr. Justice Sutherland, the author of the court's opinion in Humphrey's executor, likewise wrote the opinion for the court in Springer v. Philippine Islands, in which it was said, "Not having the power of appointment, unless expressly granted or incidental to its powers, the legislature cannot engraft executive duties upon a legislative office, since that would be to usurp the power of appointment by indirection, though the case might be different if the additional duties were devolved upon an appointee of the executive." The Commission's powers. Thus, on the assumption that all of the powers granted in the statute may be exercised by an agency whose members have been appointed in accordance with the Appointments Clause, the ultimate question is which, if any, of those powers may be exercised by the present voting commissioners, none of whom was appointed as provided by that clause. Our previous description of the statutory provisions disclosed that the Commission's powers fall generally into three categories: functions relating to the flow of necessary information, receipt, dissemination, and investigation; functions with respect to the Commission's task of fleshing out the statute, rulemaking, and advisory opinions; and functions necessary to ensure compliance with the statute and rules, informal procedures, administrative determinations and hearings, and civil suits. Insofar as the powers confided in the Commission are essentially of an investigative and informative nature, falling in the same general category as those powers which Congress might delegate to one of its own committees, there can be no question that the Commission, as presently constituted, may exercise them. As this court stated in McGrain, a legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, and where the legislative body does not itself possess the requisite information, which not infrequently is true. Recourse must be had to others who do possess it. Experience has taught that mere requests for such information often are unavailing, and also that information which is volunteered is not always accurate or complete. So some means of compulsion are essential to obtain what is needed. All this was true before and when the Constitution was framed and adopted. In that period, the power of inquiry with enforcing process was regarded and employed as a necessary and appropriate attribute of the power to legislate, indeed, was treated as inhering in it. But when we go beyond this type of authority to the more substantial powers exercised by the Commission, we reach a different result. The Commission's enforcement power, exemplified by its discretionary power to seek judicial relief, is authority that cannot possibly be regarded as merely in aid of the legislative function of Congress. A lawsuit is the ultimate remedy for a breach of the law, and it is to the President, and not to the Congress, that the Constitution entrusts the responsibility to take care that the laws be faithfully executed. Congress may undoubtedly, under the necessary and proper clause, create offices in the generic sense and provide such method of appointment to those offices as it chooses, but Congress's power under that clause is inevitably bounded by the express language of Article 2, subsection 2, clause 2, and unless the method it provides comports with the latter, the holders of those offices will not be officers of the United States. They may therefore properly perform duties only in aid of those functions that Congress may carry out by itself or in an area sufficiently removed from the administration and enforcement of the public law as to permit their being performed by persons not officers of the United States. This court observed more than a century ago with respect to litigation conducted in the courts of the United States. Whether tested, therefore, by the requirements of the Judiciary Act, or by the usage of the government, or by the decisions of this court, it is clear that all such suits, so far as the interests of the United States are concerned, are subject to the direction and within the control of the Attorney General. The court echoed similar sentiment 59 years later in Springer v. Philippine Islands, saying, legislative power, as distinguished from executive power, is the authority to make laws but not to enforce them or appoint the agents charged with the duty of such enforcement. The latter are executive functions. It is unnecessary to enlarge further upon the general subject since it has so recently received the full consideration of this court. Not having the power of appointment, unless expressly granted or incidental to its powers, the legislature cannot engraft executive duties upon a legislative office, since that would be to usurp the power of appointment by indirection. Though the case might be different if the additional duties were devolved upon an appointee of the executive. We hold that these provisions of the Act, vesting in the Commission primary responsibility for conducting civil litigation in the courts of the United States for vindicating public rights, violate Article 2, subsection 2, clause 2 of the Constitution. Such functions may be discharged only by persons who are officers of the United States within the language of that section. All aspects of the Act are brought within the Commission's broad administrative powers, rulemaking, advisory opinions, and determinations of eligibility for funds and even for federal elective office itself. These functions, exercised free from day-to-day supervision of either Congress or the executive branch, are more legislative and judicial in nature than are the Commission's enforcement powers, and are of kinds usually performed by independent regulatory agencies or by some department in the executive branch under the direction of an act of Congress. Congress viewed these broad powers as essential to effective and impartial administration of the entire substantive framework of the Act. Yet each of these functions also represents the performance of a significant governmental duty exercised pursuant to a public law. While the President may not insist that such functions be delegated to an appointee of his removable at will, none of them operates merely in aid of congressional authority to legislate or is sufficiently removed from the administration and enforcement of public law to allow it to be performed by the present Commission. These administrative functions may therefore be exercised only by persons who are officers of the United States. It is also our view that the Commission's inability to exercise certain powers because of the method by which its members have been selected should not affect the validity of the Commission's administrative actions and determinations to this date, including its administration of those provisions, upheld today, authorizing the public financing of federal elections. The past acts of the Commission are therefore accorded de facto validity, just as we have recognized should be the case with respect to legislative acts performed by legislators held to have been elected in accordance with an unconstitutional apportionment plan. We also draw on the court's practice in the appointment and voting rights cases and stay for a period not to exceed 30 days the court's judgment insofar as it affects the authority of the Commission to exercise the duties and powers granted it under the Act. This limited stay will afford Congress an opportunity to reconstitute the Commission by law or to adopt other valid enforcement mechanisms without interrupting enforcement of the provisions the Court sustains, allowing the present Commission in the interim to function de facto in accordance with the substantive provisions of the Act. Conclusion. In summary, we sustain the individual contribution limits, the disclosure and reporting provisions, and the public financing scheme. We conclude, however, that the limitations on campaign expenditures, on independent expenditures by individuals and groups, and on expenditures by a candidate from his personal funds are constitutionally infirm. Finally, we hold that most of the powers conferred by the Act upon the Federal Election Commission can be exercised only by officers of the United States appointed in conformity with Article 2, subsection 2, Clause 2 of the Constitution, and therefore cannot be exercised by the Commission as presently constituted. In number 75-436, the judgment of the Court of Appeals is affirmed in part and reversed in part. The judgment of the District Court in number 75-437 is affirmed. The mandate shall issue forthwith, except that our judgment is stayed for a period not to exceed 30 days, insofar as it affects the authority of the Commission to exercise the duties and powers granted it under the Act. So ordered. Mr. Justice Stevens took no part in the consideration or decision of these cases. And we'll stop there for today. And as always, if there's any case you'd like me to read, just drop in the comments and have a take a look. Thank you.